All right, well, let's get this training done. It's been about 4 years since ALAC has gone through a more of a comprehensive training. We have done some trainings of various. I remember we did a B5, B6. So anytime any member needs additional information, never hesitate to reach out. I do want you to know that there are a lot of resources that are available to you. The Department of Revenue, with its 2023 Act 73, they established DAB, which is their alcohol division now, their division of alcohol beverage. And they have a few more staff members now. And so the last screen does have their phone and email. And if you're stuck and can't get a hold of a staff member, of course, you know, the CTO as the clerk treasurer's office as the staff rep to ALAC, we are always happy to chase down answers to your questions as well. There are special event guidelines. The links, I'll send this PowerPoint out to you so you can actually access these links, but you have Council Policy 66A, the special event guidelines, the state statutes. When I put it all together, it came into a binder that is, this is it. And I don't know how many of you are still good old paper, but if you want a binder, I'm happy to make you one, but I thought I would take orders only and not just assume you want them. So let's just start with kind of, you know, what is ALAC? It's composed of 7 people. It needs 2 council members. And the purpose of the committee is to advise the council on applications for liquor and related licenses by reviewing them, and by providing a research source for drafting alcohol-related ordinances and policies. And we are going to, did you get snuffed, Larry?
No,
he
gave me a cup the day is made, you know, the city attorney's providing
City
coffee.
attorney is serving coffee. That is, we are a full-service organization.
I'm back from my,
So we will talk about some ordinances and policies that, you know, you have brought forward, and I will explain to you how to get those to council. That is one of the reasons why you do have 2 council members on your ALAC. So your tools for decision-making, you need to, as a member of the community and a member of this board, to make sure that you are trying to be fair and impartial. You'll need a little bit of knowledge of Chapter 125. That is, to me, one of the toughest chapters in my job. I have a lot of chapters that I have to get to know. And alcohol law is very perplexed. It's, I won't lie, the Tavern League is one of the largest lobbyists in the state, and they lobby for a lot of things. In fact, I think they currently stand at the 2nd largest lobby. We have not increased beer tax in over 40 years. And I think that might be one of the reasons. And so there's a lot that goes into the getting the law to go. Well, then you also have your local city ordinance, and city ordinance can be stricter than state statute. It just can't be in conflict with state statute. And that can get a little bit challenging. So everybody's got various roles, and we'll start with yours. Yours is to review the materials in the packet before the meeting. If there's questions or concerns, reach out to us. We're happy to chase down answers for you. Attend your meetings and be ready to make recommendations on the applications. Just know that in order to revoke a license, the license holder must be provided due process. And I will spend a lot of time on that. Once we issue a new license, you know, just keep this in mind. Once we issue that new license, taking it back is going to be a very difficult and expensive process, because due process means we hire attorneys, and we have hearings and special meetings of the council. And so we do need to vet those applications very carefully. And since I've been on staff, I know that ALAC has done a great job of that. You're not an enforcement body. And so the gentleman down on the end in a uniform, he is your muscle. And he is, him and his fellow law enforcement officials are the enforcement and compliance authority. A lot of times you may call me and you may say, well, I saw this sign or I saw this on the end cap, and while I may go and get more information to save them time, the only thing I'm gonna do is call Deputy Chief Ratzloff and say we have a compliance call that we need to make, and then they will go and take care of whatever needs to be taken care of. So just remember, you're an advisory body, and enforcement should always go through the police department. And then you're gonna provide that positive or negative recommendation to council with your reasons.
I have a question on that. So what should we do, or what are we obligated to do as a group or a board here as far as non-licensed, say your hairdresser is giving away beer, or all of the illegal gambling machines in gas stations? I mean, are we supposed to be tattletale agents, or is this a city thing, a state thing? Like, where are we supposed to take these?
Well, I would say that, you know, as a resident with the knowledge of the law, I would not say that it is your obligation at all as a member of ALAC to be the tattletale agent. But as a resident of the community and wanting to, you know, and I would view my job the same as yours. You know, we're residents. We want the safety, peace and order. You know, we want everybody to kind of comply. And so I would encourage you, if you see something, say something. You know, the Janesville Police Department can't be everywhere all the time. And you might be disappointed in their reaction. You know, I will say in my staff office, we're constantly tattling on unlicensed food trucks. To me, that's really important. I want to make sure that the health department has been in those trucks and that we're not making people sick. Sometimes the police department will just go out and knock on their window and say, hey, you got to hop over to the clerk's office and get a license. We're not going to cite you. You're not going to get a ticket. And so that might be their answer. The liquor store gaming machines is a big deal. The DOR recently came and did a pretty major bust. I believe it was 10 locations that was found with machines. But if we don't know about it, we can't respond to it. So if you do have questions with that, I'm constantly getting the, hey, I noticed a liquor store was serving samples. Well, that's a new thing. It's part of the 2023 Wisconsin Act 73. You might be surprised at the hairdresser rules now and the paint studio rules now. And then, of course, if it's not open to the public and they're there afterwards, what the rules might be. But we will, if you bring it to the police department, they're going to look into it. If you bring it to us, we're going to see if the police department will look into it, because we are not a compliance body or an enforcement body either. Does that help? Okay. So the city attorney, who is joining us for training, he is here to assist us in matters that need legal interpretation of the law or policy. We have some pretty interesting liquor laws out there that have been kind of wrapped around corners for one reason or another. He'll assist in drafting changes to ordinance and policy, so he and I are going to spend a little time together this month. And then he'll serve as the city's legal representation during enforcement. So the city attorney represents the city. And so I say that because if there is another matter that comes before ALAC, there may be a need for an outside counsel in certain situations. And then you might be surprised that my job is relatively simple. We receive the applications and the fees. We send it over to Deputy Chief Ratzloff for the required approvals. We put it on the agenda for your consideration. We move it to the council agenda when it's there. We process those licensed based on the actions of the bodies, and then we maintain those documents. So, well, it's not as complicated as I might make it seem sometimes, Councilmember Squire. I sometimes need to feel important, and so I make up stuff that sounds fancy.
We'll try and help you feel that.
It's not that hard. And then finally, the police department, I should probably advance the slides as we go, huh? The police department, they're the main compliance authority. And so they're going to make recommendations on all of your bartender operators, on all of your agents, and state law, and this was also a part of the new law, also requires that of the owners and members. So we're gonna need to look at some of our background check fees, to make sure that we are covering our license fees and, making sure that we're covering those costs. Inside Council Policy 66A is about a page and a half of, I don't know, I guess you would call them guidelines, for whether or not one should be approved or not approved. What's on your screen right now, though, is something that was put up by the League of Municipalities, and it's very small, but it is also, it'll be larger in the presentation when I send you the larger screen. But it's a flow chart that basically speaks to the law. When Deputy Chief Ratzlaff is going through these applications, he also has to make sure that he's not violating any employment laws. And so all of the criminal activity that might be reported, any of the charges that are against somebody that they've put on their license, it has to apply to the license. It has to substantially relate to the licensing activity is kind of the legal lingo that we've been given. So, and that could be, you know, if you're a Class A operator selling, you're operating a till by yourself, you know, if somebody had a grand theft, that could be considered substantially related to the licensing activity because they are dealing in the transaction of selling alcohol. So if they have multiple OWIs, definitely substantially related to the licensing activity. And so there are various charges where, you know, maybe we have to be a little more lenient because we have to be careful within that labor law area. So go ahead, Steve.
My question is when we review these and you review the applications, we see the agent. How in depth, like, were you with the True and the town suites process with reviewing the LLC specifically, that they're on board, that they're not doing anything illegal?
Essentially, my process is if there's a name on the application, rather it be the corporation name owned, the person, and then like the actual managers, I check them both.
And depending on the charges, you know, there are various levels and depths that the police department can go through. I mean, you can go as far as a national check if they're listing other states, but that's not required in the background check of an operator, provided that they have stated they've lived in Wisconsin for the required amount of time. And so the state statutes require you to be a resident of Wisconsin for 90 days, but we have an ordinance that says Rock County for an agent. And so those have some various rules there too. So I hate to say it, but it kind of depends on that. Yeah.
Yeah, I think it's an interesting point you bring up about, you know, crossing the lines on employment law and that sort of thing, because if someone decides to hire an individual with that background, you know, what risk, you know, we can't manage their business risk, but we need to manage the risk of an individual who has shown a propensity to break the law, to manage something that includes alcohol distribution, et cetera. So I guess kind of, you know, Chief or Deputy, I mean, kind of your take on that, or Lori's, because to me, that's where the line is on the risk. You know, the risk to the business, that's their, you know, we can't run their business for them, but the risk to the community, where does that fit in?
Agree with you 100%. So like when I do a denial, that's like, I'm just fact reporting. And then the committee gets to decide, do they want to uphold the denial or allow to grant the license?
Yep.
So I just present the information.
Yep.
And for example, there was one gentleman, he was convicted felon of an armed robbery 25 years ago and has had no police contact since his release, which was about 10 years ago. And I'm like, yeah, you know, I think he did his time,
Yeah.
you know, until he shows something other to us, you
Right.
know, that was one that I'm like, yeah, I would grant that one.
Well, like even the one, I'm sorry, the White Oak that, I mean, she had something, what, 15 years ago or something, and that
Correct.
sort of thing. You go,
Correct.
okay. And no
In-
other even minor activity since then, so.
So on the application, it says 5-year look back.
Yeah.
But our, I believe it's 66A says 2-year look back for alcohol-related incidents and 1-year look back for drug-related incidents.
Okay.
And then my position, and I'm glad we're having this training because this is my interpretation, and I don't know that it matches everybody else's interpretation. But for example, I look at drug distribution as significantly related to the license, right? So if you are convicted within, but according to our policy, I can only look back 1 year. But in my interpretation is that would be a denial. And and a lot of times people don't disclose, and I'll just write, well, they just didn't disclose, they didn't even fill out they're being dishonest in their applicant, as
Yeah.
their, and so that would be the reason for denial regardless of the charge or whatever's out there.
That is a point, especially for our new ALAC members. If somebody does not disclose a charge, and we have recently redone our application, it is almost repetitive to asking you to disclose your criminal activity. If you choose not to disclose or you forget that you had it, the automatic action of the police department is going to be denied, because that is what our ordinance states. Our ordinance also states that if you don't disclose, you shall be denied, and then you can reapply in 6 months. Now, all of that being said, you have to understand that any applicant who is denied has the right to appeal. And so while you might kind of have to weave between the ordinance of, oh, they can reapply in 6 months and we must deny them, they were denied, but they also have that right to appeal. But you as a body also have the right to say, our ordinance says you didn't disclose. Your responsibility is not to determine whether or not you believe their story about being in back pain or being late to pick up their kids or whatever. That's not what you're hearing their denial on. It is the why did you not disclose this on your application regardless of excuses. And if they're willing to not disclose that, what other activities as a licensed bartender and operator are they willing to not disclose? And so, your job is to kind of be an arm of that. How are we going to keep that public safety, peace, and order intact?
All right, just one other quick point. I new to the committee, you put this together very well. We're not here to police
Yeah.
the business. However, if that agent or operator wants to hire somebody who is at risk, they can do that, but that's on them. They don't have to be a licensed
That's right.
bartender,
And
operator.
that's when they say, I won't have a job. Well, that's not true. You can actually work under an agent, a licensed owner, a licensed operator. You just can't work alone as an unlicensed individual. So we're not taking your right to employment away. We're saying, come back when you better understand the rules.
Responsibilities are not given,
They can reapply though within a period of time.
6 months.
6 months, so. Excuse me. If they have that and we deny it, they have a 6-month period to clean up their act and come back and they can reapply. And then, of course, we have to struggle with how we're gonna go
Right.
at that time.
I think the statute, I think it's 111.335, talks specifically about discrimination, not only in employment, but also licensing.
Yeah.
So there's rules in there that say you can't discriminate even in the licensing process. So it's more specific, but still ambiguous to a degree. The other thing that makes it difficult, if someone applies and they have a pending charge, it could be a felony, could be an OWI, could be whatever, it's pending. They don't have a conviction yet. So my interpretation, Wald, correct me if I'm wrong, as long as they disclose that on their application, cannot deny until they've been convicted, which then either requires us to then monitor their status and then go through the process of revoking their license or wait the 2 years for the renewal.
Well, you could deny. You could deny even though it's a pending arrest, as long as it substantially relates to the purpose of the licensing, so.
All right, perfect. There we go.
One more statute before we move on from that is, it also does say in chapter 125 that we shall not issue a license to anybody that has been convicted of a felony unless they have been duly pardoned. And so that is also one area where we're like, well, there's a felony on this. Well, it might not be for the proper license. And so it is very intricate, and it's easy for us to screw up too. So I ask ALAC for a lot of grace between the police department and the CTO and the city attorney's office while we chase these things down, so.
I think though, Lori, between, the three of you over there, the idea is how do we maintain consistency in managing our risk profiles that we're looking at and approving or denying or whatever we do. So I think that's, because we have people coming in and out in these chairs, that's the consistency that we have to look for in your recommendations.
That is absolutely the problem, right? Because the former deputy chiefs before me may have had a different interpretation, right? So how do we keep it consistent just within our house, much less consistent with the ALAC and everybody else that changes positions? So we are going to be sitting down and working on like a flow chart of this. So there is that consistency that transfers from person to person to person.
Perfect.
Some of the changes we hope to bring back to ALAC first before we go to council in that first meeting in July is to kind of streamline and clean some of this up, because the more we pour into it, the harder it is to siphon, right? And so we'd like to kind of clean it up and make it a little clearer. And, the league, there's the DOR, the league, this isn't a new wheel. We're not, we're just gonna take best practices and go.
And in 125, it says, you can't issue to a convicted felon unless pardoned, but then the next line under that says, you cannot deny based on someone's conviction or arrest record.
There's one.
Like, wow. And that's, I think it's left to case law to end up in a courtroom to decide what that means.
Yeah.
And I don't think it's been fleshed out yet.
Lori, I think this really extends just the basic knowledge when it removes all the emotional connection, the emotional pleas that people are coming and saying, but you must because I am having a hardship. That removes all of that when we just extend from not just case law, but we extend from the police department. We extend on our city ordinance. This is the way it is. As much as I appreciate all of that, come see us in 6 months.
Yeah, I mean, you can look like you're being very insensitive to the situation the person is standing in, but that is just not our job. And, at the end of the day, what are we looking for? You are appointed to represent this community and make recommendations on that safety, peace, and order. So we want to make sure that we have people in our businesses that can be trusted, that aren't starting up little side businesses to advance their criminal careers. And, we're going to do that in the best arena that we can. So, and we're going to try, we want to bring you enough information forward, and we're trying to pull together to make sure that you have a complete set of information to make your decisions on. We don't want you to have to dance between the lines. So I think this training hopefully will set some of that up so that we can all be successful going forward.
Some of these, even with the flow chart, I don't think we're gonna get, under every circumstance. There's gonna have to be some flexibility there. And for Steve, since you're new, any resisting or obstructing an officer is automatically a denial within the 5-year time frame, because we look at that as what level of cooperation can we expect if there's an issue at that establishment. And if they've already established that they're going to lie to us, not cooperate, resist, fight with the police, whatever, that's a denial automatic. They do. They do.
So finishing up on the applicant, right? They need to complete a complete application. We do our best not to take incomplete applications. All that said, there are 9 of us, 10 if you include me in the office, who are going to the front desk. And Brianna and Liz and myself are the 3 who are more highly trained. If we're not in the office and that application comes in, it might not be complete. We're gonna do our best to go through it and make sure that we can get through it. The team is going to watch this training as well so that they can better understand why we do what we do. I will tell you, as far as dates go, I'm not worried about dates. As long as, you know, the application is in and we can get it processed. The law states that an applicant for a liquor license has to apply 15 days before approval. A temporary has to apply 4 days. And so I'll be bringing back a recommendation to update that language of that 15th of the month cutoff, so that if we can meet the statutory requirements and still get these, I want to be business friendly, but I also want to make sure that we're vetting things thoroughly. So I want to have a little flexibility in getting these things to you. And of course, like in the corporate, you might have noticed in the hotel applications today that the applicants filled stuff out in like February, but the rest of the stuff was kind of filled in by corporate with some later dates. We're not exactly worried about that, as we are making sure that they have taken the proper training and that we've, you know, they're ready to go, they understand the law. So when it comes to a complete application, I'm not necessarily looking for the crossed T's and dotted I's. I'm more looking for the substantial completeness of, have you lived here long enough? Have you given us your entire history? Have you completed, so that you have enough information to make your decision? They do need to attend the meetings that we say. We do provide them a Pub 302, which is to help them understand the state and local regulations and laws pertaining to their activity. I will provide additional opportunities to licensed establishments and bartenders and owners in the next year. Now that we're in renewal, I will provide some training opportunities online for them to hop on and look at, in addition to their safe server, so that we can dive into some of the local ordinances with them. I did that when I first came here and there was only one person who attended, so I was like, well, maybe there's not an interest. But I think we have to continue to do that just to make sure that we're getting that information out there, so there are no excuses not to follow the law.
Lori, do you have a database that you can be emailing or mailing these trainings and that sort of thing? Because I think you're on track with this, that if you provide that opportunity, it's not up to us to, you know, force them to look at it or do it. I mean, that's got to be their desire and to run their business appropriately. But do you have that ability to send those out? And I like that idea of just some consistency of training, so that as things change, if they miss it, that's not on us then anymore. You've provided that info.
Yeah, it wasn't until the DOR reformatted their licenses in this last year and a half that they even included an email address. So it was very difficult for us to access those. And so we are now collecting those, and we are now using email in a more productive manner to reach our licensees.
Yeah.
We didn't have that ability before, and so we are going to kind of lean on that. So we want to make sure that they can comply with that. We also, and I've been giving a little bit of a deeper agenda to the chair here, and there is one place on the license application that I would like ALAC to confirm with the agents when they appear. It's very important that the agent appear with a new application. The agent and the owner should be in front of you, because the agent is going to be the one under the law that is held responsible for all license violations that occur on the property, whether they're present or not. They're taking on that responsibility, and having someone on the ALAC or somebody in the law enforcement or legal area to say, hey, do you understand this? And then they affirm yes, also helps us to push the onus onto them so that they take that position serious. Throwing anybody in that place of agent can wind up causing them some problems. And I will say, Joshua, who was here today, he really understands the law, and when he's got a question, he doesn't hesitate to ask. And there are some agents where if I could clone them, it would be wonderful. So That is the applicant's responsibility. I know you can't read this, but I want you to know that these are all the licenses in the clerk treasurer's office that we are working through on an annual basis. The bottom quarter of it below the gray line are the alcohol licenses. And the fees are set by state statute. So when you look at the $10 temporary Class B, that probably costs the city $100 to vet and issue. We are stuck to that $10 by state statute. So write your legislators, tell them it's time to increase that fee. Your beer is $100, your liquor is $500. We are kind of stuck to that fee. The one fee that we can move along is the operator license, a temporary extension of premise, a permanent extension of premise, sidewalk cafes, things like that. We can look at our local fee, but the state licenses are set by state statute. Okay? And I want you to know before we go to the next section is this term called municipal authority. Municipalities issue alcohol beverages, and you have municipal discretion. It's broad that first time, and I brought this up earlier in our training. That first time we issue, that authority is very broad of you. You want to make sure that that applicant is vetted. Once the license is issued, then that due process is required to take it away. So we need to kind of know the ordinances, know the state law. There was a big change in state law between 24 and 25, which is why we're going to be bringing some changes forward. Now that I've been here almost 4 years, there's a few things that are in like Council Policy 66A that it's just repetitive to the statute. I'd like to make a nice little condensed package for you so you don't have 14 pages of policy, 50 pages of statute, 30 pages of ordinance. We'll make sure, I want to move as much as we can to the ordinance, which is publicly available to everybody, especially you, and make sure that it's all in there so that that municipal authority is there. Leave policy decisions where we need that flexibility, but this really is the time to look at that based on those law changes. So let's talk about bartender licenses. They are good for 2 years. And we are in a renewal period, and so we have just been hammering the police department. I don't know how he gets anything else done because it's hundreds, and they've all got to be vetted. The fee is $72, and when we set fees for licenses around here, we are supposed to be setting the fee for the actual cost to issue the license. So in a 2-year license, you know, you're looking at us taking it in, moving it to the police department, running a background check, getting it issued, mailing it out, and then making sure that we know where everybody is. We recently got a licensing program that helps us also put like where our operators go, like what their current employer is. We are able to then sort that out and go, isn't that strange? And it didn't happen here in Janesville, but in my last place of employment, we were like, Applebee's has not had an employee apply for an operator's license since 1995. That's really weird. So we sent law enforcement over there, and sure enough, they thought, well, we just only thought we had to have an agent. Well, the agent can't work 24/7. And so those are some of the things that we can now run reports on to make sure that, you know, not only are they understanding the law, but we're helping them with that. So an operator's license, it's for anybody who is 18 or older and serving or selling alcoholic beverage in an establishment with a Class A, B, or C license. You have to have immediate supervision, and that is the key right there. So it can be the licensee, so that's why you would have an operator's license, so you could work alone. You could work under someone else with the privilege of an operator's license. Now that privilege of an operator's license is a little weird. So if you're an individual, and Bad Brad was an individual license, which meant he didn't need an operator's license, and anybody in his immediate family could actually work on the premise, and it was assumed that they had the privilege of a license. You have that in a partnership as well. So if you have a partnership, and you're not even required to appoint an agent in a partnership, you have the privilege of an operator's license in that case. So again, kind of weird pieces to the law there. The approved agent of a corporation can be that supervisor. a person with an operator's permit or a person with a manager's license. And the city of Janesville does not currently issue manager's license, so I'm not going to get into the weeds with that. They're not exactly very helpful there. I'm really sorry about the text limit on this. I did not realize that it would be this tight. But that immediate supervision there talks about the license, members of the licensee's immediate family who are 18 or older, a licensed operator, a licensed manager, or approved agent. Qualifications, you have to be at least 18 to be an operator, but the agent has to be 21. They have to take a responsible beverage server training course. And while back in the day, I would say probably the 90s and early 2000s, you used to have to sign up for a course at a local college or go to Madison and take a course in person. It would go, you know, maybe a couple evenings, and then you would get a certificate that you were trained. And now you hop on for $12 for about 2 hours, and you click along and listen to a video and then answer a few questions. But the Department of Revenue, because it is so easy now to complete that training, the Department of Revenue says, we are going to approve the courses. We are going to say, you have to take one of these approved courses. So anybody who is hiring operators or bartenders, though they have to go through that approved course. So when we get a certificate, we have to check the list to make sure that it was from one of those approved vendors. It's good for 2 years from the time you take it, but there are some situations where we tell them, oh, well, you have to retake the training because you've been inactive for 2 years. So, you know, maybe I was a bartender during COVID, and in 2023, I let it expire. And then 2025, I came back. Well, if it was more than that 2-year window, I'll be required to retake that training. Also, if I was a bartender in another community and held a bartender's license in another community within that 2-year window, I could bring that forward as my proof of training. And this is just a list to kind of show that there are still classroom instructions, but you can see that the online instructions or the online providers are much, much more thorough, so.
Lori?
Yeah.
When we talk about the operators' licenses, do they not have a statewide license available now?
There is a statewide license available. It's extremely difficult to access on the Department of Revenue's website, which says one of two things: that they're not extremely interested in bringing this online, and you know, while they're kind of standing up, or that they're trying not to take the local, you know, licenses away. So you have to go onto the DOR's My Tax database. And then once you're in there and you've set up an account, you have to go down to excise tax in order to see the operator's permit. It is completely online. You cannot fill out a form and mail it in. So you are doing this form completely online. That statewide bartender's license or operator's license, they call it a permit. So locally we do licenses, statewide they do permits, and that is to kind of to do the separation. It's $200 for 2 years. But if you are someone who, you know, that is your primary mode of income and you want to work in Janesville, Beloit, and Evansville, you've probably paid $200 by that time. And one thing that I do want to say on operators' licenses is we have had employers fire bartenders and hold back the bartender's license that they're required to display and say, well, we paid for it. Well, a bartender's operators, regardless of who pays for it, belongs to the bartender operator. So once it's issued, thank you for paying for my license, but it doesn't belong to the employer. It is always that property of the individual. And so, yeah, statewide might make more sense. But we've had clerks on our association page, and I've been sharing how to get to it. I mean, when you've got 1,800 clerks in the state and half of them can't find it, how are you going to get, you know, Jane Bartender to that site? So, so far, I don't think we're seeing a lot of interest, but I would venture to guess once DAB gets really rolling, they may make it a little more accessible. And we were very worried about revenue this year. We have really not been impacted by that. It's pretty rare, you know, if you're gonna work at an establishment, you hopefully get enough hours and stick to your community, but you know, there's catering and things like that that you want to get into. This slide here is just simply showing in Chapter 6 of our local ordinances that a submitted application that is incomplete or which contains false or misleading information must be denied, and the applicant must wait 6 months before submitting another application. So hopefully we've covered that enough, and you kind of understand the will of the staff, that, you know, we would like to kind of uphold that ordinance unless you feel, as, you know, during that due process appeal right, that, you know, this applicant truly was not leaving anything out there. So now the process for denials, we've made a couple of little adjustments because we are required by law, once the Deputy Chief Ratzlaff denies an application, we are required to notify them in writing. So Liz will often notify them in writing and by email and just say, you know, here's your application. On the bottom, the police department has written their reason for denial, and you can look at your appeal rights in Chapter 6 of our local ordinances. They do have to appeal to the clerk treasurer's office within 30 days in writing for their reason for wanting to have an appeal. And as you have heard over the last few months, you know, some of these reasons are less than appealing, pun intended. But I think we're starting to set a precedent now to where we want to stand up to, you know, holding our ordinance intact and helping the community understand our need for following process.
I agree there completely, Lori. That's, what is the process we want to follow? And I always look at, is it an error of omission or an error of commission? I mean, do they leave it off purposefully, or do they, you know, make a mistake? And that's where it gets into it, and gets into the trustworthiness and the risk that we're putting on there. So that if you get 98% of them through this process exact, we'll play with the 2. But to give you guys the guidelines to put it in front of us to make those decisions, I like that process.
Yeah, and for me, it's not personal. If I deny and you have the authority to overturn that and approve that, and if you do that, I'm fine with that. I'm just reporting facts.
Right.
So that you can make an educated decision. That's it. It's not personal for me.
I think the trouble is, the excuse is always the thing. I didn't understand, or I was in a hurry,
Oh, yeah.
you know?
And again, any of those excuses is a tendency of what you're going to do in your job situation as well.
Exactly.
That's where you're.
You have to
So-
kind of weigh all
Yeah,
that
but
conversation and see where
Yeah.
you're going.
So I've been trying to develop, you know, this is the process for ALAC for denials. This is the process for a new application, and trying to standardize the steps, you know. So having the chair announce the applicant, and then having them state their name and address, and then kicking it to the police department to let them explain the denial, and to try to keep the process in a flow to where we're sticking to the facts, and we're not just immediately getting into that personal emotional issue, to where, you know, if your mindset is to start with the facts, then you'll be able to listen to whatever they're saying and apply that logic and reason to, well, you know, I can see this or that. And so that is, you know, this is the process that we have kind of developed. And as the chair, Heather, you are more than welcome to change this process. Just let us know if there are things you don't like, but these are kind of the way we'll move applications forward, we'll move denials forward, to just kind of keep things consistent and, you know, make sure that you all have information moving forward. So I'm going to move pretty quickly through license types, this next section here. How someone applies, it depends on the structure of the business, and we have had some very creative license types and applications over the last few years. If you're a partnership, you have to meet all these qualifications except for the proof of a seller's permit. Partnerships have to provide that proof of a seller's permit. Corporations, LLCs, and nonprofits, they have to appoint an agent in charge. If that agent quits, they are supposed to, within 10 days, appoint a new agent and make that appointment noticed to the clerk. Now, we don't bring change of agents to ALAC, but we do run those change of agents through the police department, and we do not send an amended license until they have had a background check. That is one place where I think our licensees could do better. Sometimes we aren't finding about a change of agent until renewal. And so that is a message we got to get out, that you have 10 days, that when your agent quits, that's your responsible party on the license. So we need to make sure that we have that current information. Officers and directors must be 21 or over and have a suitable criminal background. Now, I didn't write that, the state did. I think what they're trying to say is not have a long laundry list. And then the agent has to meet all their criteria. We do verify permits, seller's permits on the state website to make sure that they are in good standing with the state. Seller's permits does allow them then to sell, and it means they're reporting their sales. Retail alcohol beverage licenses for individuals. Now, we don't have many sole proprietors, and I keep talking about bad Brad's, but when he passed away, that created a real issue because he was not married, which meant there was not a immediate next of kin. And we did not have this transfer in line when he passed, and so there's this active license with nobody owning it, and it's sitting on a premise. And we can't transfer it. So this sole proprietor can be a nice thing to have, but it can also run into some licensing issues when the unexpected happens. So you also have to not be a habitual law offender. That is one of the string of words that the police department will receive from the state on trying to determine what a habitual law offender is. That makes a lot of fun for Deputy Chief Ratzlaff too. You have to be a continuous Wisconsin resident for 90 days, but we have made our ordinance more restrictive, and we have said Rock County. I may bring forward in July a recommendation that maybe we should extend that to anywhere that borders Rock County, to extend that a little bit with that. But it is kind of a nice, I like that they have to be kind of local, because if we had somebody who was an agent, in Madison, Janesville, and Racine, that's an awful lot of territory to cover and keep your ear on the ground here.
Does it matter, again, the licensing, if someone lives in Illinois and wants to practice up here, they still have to follow all the Wisconsin laws, correct? It has nothing to do with where, so if you're going to allow that, are you going to allow it across the border, or what are going to be your? Well,
I was going to suggest that it'd be Rock County or municipalities that border Rock County.
Okay.
And so, if we did go into South Beloit, then they could not be an agent. And as somebody who has worked on the border for 6 years, it's very interesting, because you get a lot of that where you can't be an agent because the law limits us to Wisconsin, right?
Okay. Yeah.
And so even if we said, but you can probably be from, Fort Atkinson, or you could
Right.
probably be from, within that half an hour of Rock County or whatever it is, but you cannot not be from Wisconsin to be an agent. Now, you can be from Illinois and own a business here and be an applicant for a Class A, Class B, Class C license.
Okay.
You still are going to be held to Wisconsin,
Right,
rules and regulations.
Okay.
We do have quite a few who are out of state, especially our corporations. I mean, you look at our Hy-Vees and festivals, and,
Yeah.
they're all, we've got Iowa, and I think we've got even Oklahoma. Chili's, I know, is out of state
I
too.
mean, that's
So
just understood.
yeah, it's just understood. We are required by law in our office to provide a Pub 302 that actually it says Wisconsin law for municipal retailers, alcohol retailers, that they get when they get their license. We're also required by law to give them the safe ride information on a Class B, so that license holders know that they can provide that to their patrons and receive a safe ride home.
I think the thing with the agents, several years ago, that they could be almost anywhere, and we've had a very difficult time having agents respond to issues in Janesville. And that's when I think the ordinance got changed to make it Rock County, because we had agents in Milwaukee, we had agents in wherever. And to keep them responsible for what was going on here was very difficult. And that's when that change, I think, came into being.
Yeah, Milwaukee is a few counties away. I don't think I would make
No, but I'm just saying, that's.
any suggestion to go that far out, but maybe to expand the territory a little bit as, you know, as hiring becomes a little bit of an issue. I try to balance, you know, making sure that we can have compliance with making sure that our businesses can recruit qualified individuals, and keeping us restricted to Rock County only may limit somebody who lives in Avalon or Union, which is right on the border of Rock County, but it's in Dane, so they can't be an agent, but it's only a 20-minute drive to work. We want to make sure that we can also be, you know, employer friendly.
I just pointed out, I think restricting and keeping it close is good, but.
I agree.
To get too far out is also an issue.
I agree. So Class A, I always tell everybody, think of Class A as a way. I don't have a problem with my parentheses here. You will notice that Class A with just the A in paren, and I say that's little a means beer only. Big A, meaning I put paren around the whole thing, and this is the state's classification. You'll see this all over in the statute. The big A with the whole word in paren, that's going to be your full liquor license. So in trying to keep the paren easy, I always say that's little a, that means beer. That's little beverage, little alcohol. Big A is intoxicating liquor. All Class A is for off-premise, for taking it away and drinking it somewhere else. There is no quota on Class A's currently. Data with the alcohol policy, Wisconsin alcohol policy, they suggest that it's best managed with density of outlets in a specific area rather than having a simple number. So after I started, I had brought forward the request to remove the quota on Class A's, and I have suggested that if we move to a different model, that this be the model. I don't know what that model would be. You know, some communities have a distance from door to door. And I think when you're looking at Class A's, especially when you have the big A where you're selling liquor, you want to make sure that there's not an outlet on every corner. That you don't have, you know, 4 gas stations that are selling alcohol in that one corner. What that density does then, that creates density issues, and it can become a problem with calls for service in your community. You can see more you know, drunk driving episodes. And so Wisconsin alcohol policy, their job is to assist communities with coming up with safe alcohol laws. So they are not necessarily a law or compliance. They are a little bit more in the area of, I guess I would say, prevention and responsible policy that would help us, you know, deal with issues in the community that we might be struggling with. I am unaware of issues in Janesville right now where we have a lot of density issues that says there's too many here, too many there, but we have recently had some come and say, well, if you issue this license, you're going to put me out of business. That's capitalism. But if it's density, then we should look at probably doing a density of outlets ordinance instead of quota.
Lori, we have a number, and you know this as well, we have a number of alcohol outlets that are within neighborhoods. And that's one thing that I know that we've talked about is trying to limit those numbers in those neighborhoods, because when you have a school and a church and a residential area, this isn't your commercial corridor necessarily. We're talking about neighborhoods that are affected, and how do we move forward? How do we limit that and still stay within state law? It's tough.
And as a body that helps the council set policy, that is something that you are all able to put on an agenda and discuss and put forward to council, and staff is happy to work on establishing an ordinance based on, what we see in best practices in other communities, or, with respected organizations that can help us with that. So, if that is something that you wish to bring forward, you, as a body, all you've got to do is say, get that on the next agenda. We'll make it so. In Janesville, we have something called a separation ordinance. Not all communities have this rigid wall separation ordinance, but you'll notice in the city of Janesville that any place that there is a Class A license, you will see a separate entrance with separate rigid walls going through to that. The one exception to that would be places where there is not a gas station attached to it, or a pharmacy attached to it. So those are kind of the two exceptions where if it's not a pharmacy or a gas station, we can allow you to have an 80 square foot area where you can station your alcohol. Currently, we're looking at Sentry, and we're looking at Aldi, and there's probably a couple more that are out there that are doing this. But the separation ordinance, I would probably not recommend ending it unless we are working with our community, because when you require a separation ordinance to somebody who's building a new business in town, you are asking them to spend tens of thousands, if not hundreds of thousands, and in the case of maybe, like a Hy-Vee style, maybe upwards towards the million, to make sure that they can meet our ordinance compliance. And if we were to just strip that away, I could see a lot of our businesses being pretty upset by that. So,
But I think that gets, sorry, this is voice from above for you. It gets back to even what Heather's talking about. How are we making it easier for to what you said, the businesses to run it correctly with point of sale, with supervision, all those type of things? What is the goal we're trying to accomplish in that safety and risk management? And just putting up a wall, may make it even more difficult for the organization to manage their process based on getting qualified staffing and a number of other things. So that gets to questioning what is the right process. It may have been appropriate at one point in time, but are we actually creating more problems for our businesses to manage? How do we manage the risk we're really looking at in this? So
I can just comment that in the years I've talked to some of the stores that have open liquor stores that have the separation, and some of the comments that I have received have been on the positive end, where they're saying, we like it because we unlock the door at a certain time and we're open for business. We lock the door and we're closed.
Yeah.
And we're not dealing with it within the main portion of our grocery store. So, there's some
Right.
people really think it's beneficial to them on how they run their business. So, I guess sometimes you get somebody coming in and wants to open a business, and they don't like it.
Yeah.
But, what do you do to the businesses that have had it and spent that money for years and say it's a good business model?
Yeah. What, Mo?
Times change.
Times change.
I think it's a ridiculous rule, but I don't.
Yeah.
I think some of the things that you can consider instead of just saying we're going to eliminate that, though, would be to look at your 80 square foot rule.
Correct.
Your 80 square foot rule prohibits anybody in a gas station or anybody with a pharmacy. And so those are three things you could look at right there. Like, is this a little restrictive to the Class A situation? There are Walgreens all over the country that have liquor. There are also Walgreens all over the country that are closing because they can't make a business. Their motto used to be a pharmacy on every corner. And so there's pros and cons to all of that. But maybe 80 square feet isn't enough in some areas. But those are three things that you could look at almost immediately to maybe look at your the business side of things before wiping the separation requirements out. I don't have an opinion on it. I just know that we are more of a rare community in the state of Wisconsin, And, you know, when I'm out there and we're talking clerk world stuff, it's, you have a what? So, right now, and this screen is kind of an important one too, where I'm going to bring forward in July. I still need to do some data gathering, but currently we require a Class A license holder to hold both a beer and a liquor license. And I think maybe perhaps that should go away. It used to be quoted because of our quota-driven system, and now that we've eliminated, this might just be a bit of a leftover. But wouldn't it make more sense if our quick trips were only offering beer, if that's what they wanted, but we make them get a liquor license, so what the heck, we'll sell vodka? So if we were to make this go away and you could have just a Class A beer only without a quota restriction, if we're gonna go in this direction, you may wanna consider those density limits though, especially for a beer only. But this is just maybe something that we could, you know, help with, you know, the saturation of liquor sales being throughout our community. Class C is wine, and in the 2023 Act 73, it used to be that you could only have a Class C wine if you were a restaurant, and you would file an affidavit with us that said that your sales were 50% food or more, and then you could have your Class C. And now that has been removed. There is no limit to who can have a Class C, which makes it a little bit easier to have a Class B and a Class C. Maybe I just want to sell beer and wine. I don't want to have alcohol, and I'm in an A situation. And so now I can have a Class C wine and a Class A beer that goes with that. So very rarely can you have more than one license on a single premise. And I have a slide for that. But the Class A cider came along probably 6 or 7 years ago. We don't have any here because usually if you're doing cider, you are doing a full alcohol and then you don't need the cider only. Moving on to Class B, that same thing with the quotations when you see it. The little b is beer, the big quotation is your alcohol. In Janesville, we have 4 types of Class B licenses, and this gets a little weird here too. You might see some recommendations come forward on this as well, but quotas will never go away. So Class B intoxicating liquor quotas will be in place. They're based on our 1997 population formula and the number of licenses that we had at that time. For every 500 residents that we grow, we can add 1 license to our quota. We are currently sitting at a 75 license quota for all Class B intoxicating liquor quota. Reserve licenses are those that the state allows us to be above and beyond, and that is also formula driven. I think we have like 22, and they are a one-time fee of $10,000, and they are not transferable. So they're not very desirable. But if you need to open a business and you need to have alcohol for it to meet your business plan, that $10,000 one-time fee, what I then recommend if you have a reserved license and you see a regular license open up, you should apply for that one, because then it would become transferable if you sell the business. In this case, if you had a reserve license and you sold your business, the new applicant would have to apply for a new license, or they would have to pay a $10,000 fee to get it. So currently, we have plenty available, but there are communities where we can sell reserve licenses for any fee to our neighbors, but once you sell it, you never get it back. So you have to be careful with that too. Restaurant licenses are based on 65% of the sales being from non-alcohol, so it's gonna be that food, and they have a reporting requirement. That is a more restrictive ordinance than state law, and I'll talk about what state law has in a minute. And then we have our beer-only licenses. Currently, beer-only restaurants with 50% of sales from non-alcoholic beverages and food. So that's what our ordinance currently says, right? But if we had a beer-only license that was, available to anybody outside of restaurants, because right now we have some entertainment venues that have just beer only. We have Papa Doc's, and they just want beer. They don't want to have alcohol. They're throwing axes, for crying out loud. But sometimes our ordinance can be restrictive and it cannot take into account all of the business entities, and it can make it hard for us to be creative and get them up and running. So the Class B premise licensee, they may sell beer for on-premise, right? So the B is, we're gonna have it on-premise. And right now, there is a restriction on Class B for beer. We do have a quota for beer, and it's 1 per 3,300, but our local ordinance, 660, talks about the 1 per 900 residents. And right now I'm drawing a blank on which one that is. Now, one of the weird things about a Class B, and you might notice that with Hy-Vee when they had the restaurant in there, it was like, well, how are we gonna get one license type on one premise? Well, let's just be creative and give them a Class B, and because they can sell any amount of alcohol for off-premise consumption, because that's what the law allows, if they have a Class B, they can do both. And so sometimes when I think of Class B, I think of both. Even in a Class B or Class C wine, the new law has allowed for they don't call it recorking anymore because a lot of wine bottles are screw-on, but you can reseal with a tamper-evident seal. You can do cocktails to go now. You can send a partial bottle of wine home. The Act 73 was a very favorable law change to the Tavern League. The Class B reserve license authorizes the same as a regular B, but they carry an additional issuance fee. They're considered above quota, so you might know them as above quota. And then we have this thing called a temporary Class B. I'm behind on my slides, aren't I? We have a temporary Class B that in the state they call it a picnic license. And you can do wine and or beer. So there's really no limit to the number of beer licenses that a nonprofit, a bona fide organization, a lodge or society, a fair, church, or chamber can get on an annual basis, but they can only have 2 wine permits in a 12-month period. Now notice I didn't say in a calendar year. So those who are doing their events like wine walks and whatnot, they are very creative with knowing what that 12-month period is so that you're able to maximize your use of that 2 number. And that is state law, not local ordinance.
What are the rules, so certain parks and besides certain pavilions, you can apply for the pavilion and then get a special permit to have alcohol in those pavilions? Is that issued through the city Parks and Rec? How is that handled in this?
So our local ordinance allows our parks director to issue those temporary Class Bs on the public property that is a park. So public property consumption has some legal limits to it, but anything that is considered a park, Shelley has the ability to rent a pavilion and then issue a picnic license to them, as long as they follow all the rules within the special event guidelines. And that has rules for clear cups and bracelets and whatnot that goes into that. That, like I said earlier, that $10 premise, that's, we're losing money on that one. This is your Class B, B5, B6 corridor, everything in the red downtown. So special event organizers can actually request a separate permit that allows alcohol from food establishments, licensed food establishments, and consumption of, beer, wine coolers. They can do intoxicated liquor, and they can carry and consume upon closed streets. So as long as the streets are closed off, and we have one coming up this month, which we have the, what is it called? American Dairyland Bike Race, Tour of America's Dairyland, Toad, something like that. And that brings a lot of people to our community. It's a lot of work for DPW to come in and close off those streets, but it's a relatively successful event that we have within our, and they pay a $150 non-refundable fee. They come to you for it, and we issue the license, and it is well monitored. This screen talks about the retail licenses that can have a combination of licenses in its matrix. And I will also have this as a separate handout for you to look out so that it's bigger, as well as the flow chart for reviewing licenses. But basically, where there is green, it means you can have and I said it before, a Class C wine with a Class B beer. But you could, there are areas where you can't have a Class B beer with a Class A beer. And that was, where we got stuck with the Hy-Vee situation. So this is a DOR model that I will share with you in a separate handout. That really helps us understand where we can combine licenses and where we cannot. Finally, there's a provisional license. They can be issued for A, B, and C class and expire 60 days after its issuance, or when regular license is issued, whichever is sooner. It is very uncommon now. We used to issue provisional licenses when you had to go to Blackhawk Tech and take your bartender training, but you needed to start working, and we assumed that you passed your background check and you were going to pass this, and so as soon as you were done with your training, we could issue that license. Because we get so close to renewal time, if I have somebody that comes in May of 2025 and they need to start working now, but then July 1 comes and they have to pay another $72, we could do a provisional within that 60-day window of this one. It's less fee, and so we could do that until they get to the July 1. I think a more responsible suggestion might be that in year 1, your license is $72. In year 2, maybe it's $50. And then when you're within that maybe 3 or 4 month period, we drop that fee down to, $40. Instead of issuing provisional licenses, we could look at maybe doing prorated cost instead of provisional.
And
So
Lori,
these fees are not regulated by state?
Not for operator bartender, no.
But Lori, how much work is it on your part? Does it really change? That gets to that point of, are we trying to recapture your time, effort, and energy and making sure we're, applying it? I get the idea of trying to manage that 90-day window, but,
This is a situation where we're having problems with making sure that we are recouping our funds for issuing a license.
Right.
So if we're gonna have a $15 provisional fee
yeah.
to avoid paying a $72 fee, I would rather recoup a higher portion of getting an operator's license.
Fine.
I did have a few businesses reach out to me that say, $72 in May and then $72 in June that's not fair to these young people that are trying to, be a server and, put themselves through school. And I completely understand that, but to your point, that's what I stated, was the actual cost to issue the license is $72, when we are breaking that down. And at some point, I'm going to be asked to, review that fee and maybe increase it. And so that's why, we've got to look at some different models to make sure that we get that. But I don't think that the provisional fee that is out there right now is appropriate for that 60 days because it still costs more than $50 to issue. I mean, a background check, I think last time I checked was $14. This is your quota screen, and again, I'm really sorry it's so small. You see this every month in your packet. We have 75, basically our quota is that 75 Class B intoxicating liquor and 20 of the beer. We have kind of eliminated the Class A, and I keep trying to make this more readable, and it's just, because of the way our ordinances are written, it makes it a little difficult. I just want to kind of highlight a couple of exceptions to our quotas. And that's in the middle of this screen. So a full-service restaurant that has an interior permanent seating capacity of 300 or more persons is an exception to the state Class B quota. A hotel that has 50 or more rooms of sleeping accommodations, and they have either a restaurant that seats 150 or a banquet area that has room occupancy for 400. That can go into an above quota license as well. And then an opera house or a theater for the performing arts operated by a nonprofit organization. I don't know if JPAC is nonprofit or not, but if they were nonprofit, they would go in to that above quota as well. So if we currently had JPAC in regular, and, you know, we needed to have a business move in town and pick up a license, we could move them out into an above quota there. So there are some exceptions to the rules that, you know, they've been carved out over the years, and, you know, we have those in our purview. So as we kind of wrap up these last slides, I'm gonna move a little quicker because we're.
I apologize.
No worries, no worries. This is recorded, so we will pick up where we left off. Now, there are DOR fact sheets, and I list this one as fact sheet 3110. If you ever want to know about specific areas of law, this one speaks to selling, donating, and giving away alcohol beverages. And so the DOR will do a fact sheet on who can give away samples, who can give away alcohol. This one of the highlights is that you cannot give away alcohol to evade alcohol beverage law. And I think that was the DOR's reason for making this fact sheet. But they also go into talking about who can give away samples for tasting. So like in a Class A liquor store now, the manufacturer can come in, and you might see them standing by checkout offering you an ounce of their alcohol to try it to see if you like it as a sales pitch, and they can do that. Licensee qualifications, I think we've probably hit that one pretty well. I'm going to skip this page. Seller's permits, that shows they are in good standing. We've hit residency pretty hard. The waiting period, I kind of talked about that. So all applications for an alcohol license have to be filed 15 days prior to the granting, and then temporary is 4. Anytime a new license comes to us, we are required to publish it on 3 consecutive dates prior to issuance. So you should see that in the Janesville Gazette on 3 consecutive dates that somebody has filed for that license. And so we pay for a lot of that. Now, premise description I want to spend a minute on. When you are reviewing an alcohol application, please pay particular attention to premise description. Premise description, the applicant is required to particularly describe the premise. And remember how I said once we give this license away, it's hard to get it back. Once you give this license away and the premise description is given out, if they just say, you know, it's the property located at 15 South Main, you have just licensed their entire premise inside and out. So we need to make sure that it's the buildings, rooms, the land, and the area which is under the control to where alcohol beverages are sold, served, consumed, and stored. So those 4 words is what we're always looking for. We need to make sure that we agree to that premise description before we grant that license. We issue them with the premise license on the license. So when the law enforcement individual goes in and does a business check and they're looking and they see that somebody might be sitting out on the sidewalk, they will be able to see on the license that is posted on the wall whether or not they have a sidewalk cafe approved on their license or an outdoor area to be able to say that alcohol can or cannot be out there. But if we license an entire premise, pulling that back in a renewal year is not always an easy process because it requires the applicant itself, the licensee, to agree to that change. So please make sure that it's including, you know, that, and we say particularly described. So where are they holding their invoices for the alcohol that they're purchasing from the licensed wholesalers and distributors? That could be in an office area. Where are they storing their alcohol? That could be in a basement, in a kitchen. They might have alcohol in the kitchen for cooking purposes. They should include all of those areas, not just the dining room and the bar room so we want to make sure, and then of course we have to make sure that whatever we're doing is always contiguous, meaning that you can jump from one area to the other without having to cross any barriers in between. The general rule is that they're supposed to be like doors that separate and lock between businesses with your premises. And if you have a locked door, let's use a lot of the gas stations have this to where they'll have their separation requirement for their Class A liquor, and then they'll have a door in between there. Well, they do need to have their separate entrance per our ordinance on the outside of the building. But if the door is only there for staff to move stock back and forth or whatever, it has to be locked during the hours that sales of alcohol are not allowed. So we need to make sure that we understand that when they bring their floor plans. And you guys are really good about asking those questions. Floor to ceiling walls, separate entrances for each area. Exclude shared spaces like bathrooms and stock rooms. Bathrooms, that's not always a good place to, you can observe the consumption of alcohol, but a lot of times we are licensing bathrooms. If they're contiguous and they're open to being observed, that might not be an issue, but you want to be looking at the floor plans, because if you're using a shared space where the bathrooms are in a common area, and I'm right now thinking of Draft House, where you literally have to leave the establishment to use a bathroom, you want to make sure that you're not licensing that area outside of that door. So the premise description is very, very important. And I think I've hit this home. The refusal to grant a license. You get that broad discretion when you're in the beginning, but then after that, you have to go into your possible reasons for denial, and then you're going to have to also offer that due process. Now, in the beginning, you can say, this might have and Heather, you talked about this, about it being in neighborhoods. If it has an adverse impact on traffic or the peace, quiet, and cleanliness of a neighborhood, it might have insufficient parking or proximity to other establishments, i.e. density, the ability for law enforcement to provide services to the balance of the community. So maybe you have something that is way out on the outskirts that's going to be a 15-minute response time, and it's got a high call for service area already. That would be a possible reason to consider denial if we're not going to be able to field that compliance with it. And then again, we've kind of talked about, and Chairperson Miller used that process today for reviewing a license. And if you see things that you want to change on that, Heather, you just let me know. But to kind of try to make sure that every applicant is getting a very similar or same experience when they come before you, we will follow this process moving forward. Outdoor seating, the sales service for consumption of alcohol outside is permissible only if they've done an outdoor seating. So they'll apply for a sidewalk cafe with the third floor. That plan will be reviewed. And so they're going to be looking for things like, is the slope of the sidewalk okay to where you can put tables out on it? Is the parking far enough to where it'll be safe for them to be there? And so they will say, yes, it's okay, and then we'll bring that extension of premise to you to make sure that there can be alcohol on that sidewalk cafe. I will be requesting this year that sidewalk cafes are reviewed every year for a nominal fee of $25. It used to be that once you get it forever, but things change. We want to make sure that everybody understands the rules. So we will be asking that those get reviewed. There's never been a fee for sidewalk cafes, so I'm going to implement a small fee with an application process. That application will then be included in your package showing that the third floor has reviewed and approved it, and you're not just taking my word for it. So those are some little things that I'm trying to bring forward through our budget process this year. And of course, yeah, go ahead, Mo.
I just got and it's a personal question. You don't consider then that as so you wouldn't need extra parking because you're putting out 6 tables on your sidewalk?
And that's going to be part of the plan review that goes upstairs, because they need to make sure that there's enough parking spaces because if you're putting tables and chairs outside, that is increasing your capacity. And when you got your occupancy permit, that was based on how many parking spaces you were required to have.
Okay, so that is part of it.
So they're going to review all that upstairs within the building services division. And yeah, if that requires you to have more parking spaces, then you'll have to work with them before we do the alcohol piece.
Lori, when we look at that, would they, I mean, I don't want to speak for the building department, obviously, but when you're looking at a choice of sitting indoors or sitting outdoors, that may not necessarily increase your capacity.
Correct.
You're just choosing,
Correct.
right? So are we taking that into consideration? I mean, or don't you know?
I don't know. I don't want to speak for them either, but that's
Sure.
usually the choice that goes with it. You're right. Yeah.
Okay.
Julie?
The other outdoor areas, are they still required to only enter through the business? Like the outdoor used to come, the smoking, so people who go outside and smoke, originally they could only get there from inside the business. Is that still required?
I don't know the answer to that. I'm thinking about Charlie's right now. I see a lot of people coming up that patio and going in as an entrance. They also have a rear entrance. So Charlie's has 3 entrances with an outdoor smoking area and seating area. It's not closed off, but then we also have a place like, let's say, Sneakers, who has that closed off volleyball area to where you have to go through the front to get in. So I'm not sure. I think there may be some flexibility there, but I'm gonna have to look into that. Stumper. All right, and then
Lori,
music.
Before we get too far past this, when you're talking about outdoor seating, I know there's been a recommendation by the DOR to have tables on one side or the other. And I think for the most part, we've seen most of our businesses go toward the curb area because it's giving everybody more space, but also providing that walkway. Can we move forward and enact something along those lines that would require that space? Because I know I've seen outdoor spaces be staggered. And the justification is, well, there's X amount of feet on this way and there's X amount of feet on this way, but for your walking space, you're going to have to zigzag through these tables. And so just to kind of clarify and make a clear, I don't know, I guess a clear determination, this is how we would expect it to look or function.
I
So
think
that
we'd have to bring that to the building services division as a request.
okay.
Because we can't, just because we're coming at it from the alcohol end of it, we can't necessarily tell building services, where they're going to show from an engineering or a safety aspect what that looks like. But maybe they might be able to put when appropriate or when available, preference is, something like that. But I think we should bring that to building services.
Okay.
Without saying too much.
Sure.
A final note on outdoor seating is that, music and noise is, as long as it's not disruptive, it is allowed. But if they're going to have like outdoor buskers or whatnot, they need to get that approved. ALAC actually has the authority on that one, when there's alcohol on a sidewalk cafe. Otherwise, we do not have a noise ordinance, and they are allowed if there is not alcohol. We do have these temporary extension of premises that come to you for outdoor parties. I think you are pretty clear on the process for that. They do come to us with an application. They get 2 per year. They have to be specific, and then everything has to be ended no later than 11 p.m. on the day of the event. Outside music has to cease no later than 10 p.m. And I think we're pretty clear on the temporary extension of premise. And I in my time have not really seen a big abuse of those events. You see pretty regular customers coming through with those requests. So, just so you're aware, on a license qualification, the clerk treasurer's office will withhold licenses if any of these 3 things occur. So the law requires us to withhold licenses if you have unpaid charges with the city or taxes, if you do not have a current seller's permit or you are not in good standing with the state, or if you have unpaid alcohol beverage bills with your vendors. And so we have received from Frank's Beverage 3 different licensees who have outstanding bills. And, one of them is $60. I'd hate to withhold that license for $60, but until they pay that, I cannot issue, per the law, that license. So, abandonment of license, now that's something that is also, we can be restrictive, or we can set our rules on what that looks like. Currently, you have to be open at least one day in every 90 to avoid this abandonment of license situation. So if you are, we had one who was experiencing health issues and just couldn't stay open, and it was, well, you need to be open at least one day. Or somebody got to the end of their 6-month extension and they had to be conditionally opened. They had a conditional occupancy, and they got open, and then they had to close to complete, some of their construction. And so there is some some flexibility within this abandonment, but if something is closed for 90 days straight, that is considered prima facie evidence of an abandonment, and we could begin the hearing process. Again, when you have abandonment, you have the right to due process. So this isn't something where we can just take the license back and say, hey, we took it. It does involve due process.
What do you consider open for one day?
Open for one day.
But I mean,
I'm serving lunch from noon to 4.
whether you got customers or not,
Whether you got customers or not, you're open. Yeah, and then it resets that clock.
as long as the door's unlocked and the lights are on.
Yeah. Yeah, but you still have to have met your health department requirements, your fire inspection, your conditional occupancy with the building. So you still have to have, your basic requirements met. But, construction is the most common cause that I see this happening with, or somebody trying to sell their business. Those are the times where we have that ability. We don't want to lean on it, but we have the ability to do this, right?
Right.
And then, we also have we recently made that change about 1.5 years ago on the, extensions. So once we grant the license, the applicant who was granted the license has 6 months, 240 days to get their establishment open and have that license issued. They get one crack at it. It's a $500 fee to be able to do that, and that fee is, we're constantly having to watch to make sure that business is progressing. And it's mostly done, that cost is mostly recovered through our building services, our fire department, the cost that it takes for us to make sure that they are progressing and will hold that license. There is also you are holding a valuable license of the city, and that should not be taken for granted either. So that is probably included in that impact. Hours. So in licenses, there are hours that you are prohibited to sell alcohol. And on a Class A beer, that is midnight to 6 a.m., so state law. I'm talking to you about state law right now. Class B beer is midnight to 6 a.m. Class A liquor, 9 p.m. to 6 a.m., and Class B liquor is midnight to 6 a.m. So you have these off-premise restricted hours and these on-premise restricted hours. So when you're with a Class B beer or liquor, you're looking Monday to Friday, you can't sell between 2 a.m. and 6 a.m. And on a Sunday, it's 2:30 a.m. to 6 a.m. So those are state statute hours. Now, I will tell you that we have some local sale hours that are a little bit more restrictive because we can. And this is so small, but it is 6 a.m. to 9 p.m. So we can be more restrictive, we just can't be in conflict with state law. Product purchasing. Just understand that when we issue a license to somebody who is either doing off sale or on sale, they must purchase from a licensed wholesaler, and those invoices from those sales must be kept on premise. And in our ordinance, we do state that any licensee, through the process of them taking it and opening their business, they allow law enforcement the ability to do compliance. The Department of Revenue, through statutory compliance authority, can come onto the property and request those invoices at any time. I have been to their warehouse where they have confiscated the alcohol that was not purchased with receipts. Somebody went to local licensed, Woodman's or whatever, and bought some beer, and they have the ability to know what is purchaser or wholesaler or not. I saw a ton of alcohol that was like, you got the cheap bottom rail stuff that they poured into an expensive bottle, and they have the ability to know these things. These DOR agents are very crafty in their finding, and they will find that, they will confiscate it. They hold it in evidence just like our law enforcement division does. It has to be served and stored in its original bottle. They are not allowed to refill. That being said, in this new law, they now are allowing you to mix up some drinks and have it out there for up to 48 hours for serving. So like you can make yourself a big old batch of margaritas and put them on the back counter, and you can have that mixed drink out, and you're not necessarily required, well, all beer taps have to have the exact label of what you're pouring out has to be on it. Your margaritas don't necessarily have to tell whether or not you're using vodka or tequila to make it with, nor what brand. So there has been some movement in that area, but do know that there are qualifications for the purchasing of the beverages that they sell. Let's talk about carry-ins and setups. Alcohol beverage not sold on premise by the licensee is prohibited. So no carry-ins, bring your own is not allowed. You can't have a business to where you sell the Sprite and they bring their own setup bottle. That is not allowed in Wisconsin. That was, I think, the original supper club of Minnesota and Wisconsin. Used to be that way. You had your nice little box, you carried it in. That is no longer allowed. That being said, they do allow cocktails to go, which I have not covered in this training, but as long as there is a tamper evidence seal on a cocktail, if I were to ask to have a mimosa put in here, they would have to have a tamper evidence seal when I left with it, that a law enforcement individual could see whether or not I took that off. Sometimes we see them just putting the paper over a straw, and that's not enough. That's not tamper evidence. So we're not seeing as much of that anymore as we saw when we were going through COVID, and that was a result of COVID, but it is still allowed. And in my final slides, transfers are a sticky situation, and boy, did I learn that through our recent situation with the establishment here in town when he passed. It is the license is the property right of the person or business listed on the license. And that property right will remain even through a sale. So the White Oak situation where we're talking about there's an active license through June 30th, the next one doesn't start till July, we can't just overlap those. There are some very unique requirements that come into making sure that those property rights are kept in place and that responsible parties are kept intact. 66 and tired of owning your business is not a good reason to just give your license to somebody else and let them run it. She still is going to have to be an active part of that business for the next month. And this next slide just kind of explains that, right? So we have to make sure that we are staying on top of sales and whether or not something is going to stay with the property. Relinquishments are a requirement. If you are trying to transfer your license with the sale of your property, you will need to relinquish your license. If you're moving from, if you're just going to move down the street, you're building a new building, we may be able to transfer that license with you. That's not going to be a problem, but trying to go to another business or another municipality is not allowed. There are some common questions. Background checks, they need to be for every person, even for nonprofits. So when we have the wine walk, every applicant is vetted, so it's up to 20 different businesses can be licensed in a wine walk. All 20 of them will get a background check. Temporary and provisional licenses, they all also get a background check. I'm glad that the state has spent some time defining what is a bona fide club, we now have some help understanding who can actually apply for those temporary and provisionals. And then Do the applicants have to provide new forms every year when they renew? And the answer right now is yes. When DAB reestablished all of their licensing forms, they did not create renewal documents. And so until there are renewal documents, we have to get new forms on everybody. Now, these are 2 slides of the topics I didn't cover because we are coming up on our 2-hour limit. And so I mentioned wine walks. We talked about drinking in public, but these are the statute citations should you need to look into them. We brought up parks and what goes on in the parks with alcohol in public places.
Sorry, I didn't think that would happen. I'm late for my meeting, so I was trying to get my directions.
Okay.
Sorry.
We do have alcohol allowed by ordinance exception, and there will be another ordinance coming through that's going to include the WSCC. But we also include Tallman House and Dawson and Rotary and Riverside and Blackhawk. So if we can do that by ordinance exception, we will. Our senior center has some interesting alcohol rules, curbside sales, cocktails to go. Annexation, when somebody out bobbleheads, I don't know what it's called now, but out on 51, if that were to sell and it would be annexed in under a current boundary agreement, that liquor license, if it existed in the town, would come into the city. They do come with annexation. So whenever we're out on a town border and there's a license intact, that does come with us. There are some fact sheets that talk about catering and samples, should you want to better understand how does liquor work under catering and samples. Again, I'll be providing you in links to the 309 and the 302. These are really well done documents from the state. One is a guide for municipalities. The other is the information we give to beverage retailers when they get a license. The DOR on Tap is a quarterly publication, and you sign up for it. I'll put that link in there. You get one every quarter, and it's got great topics for you to go on. And then Special Event Administrative Policy 14 and the Special Event Guideline is another one to really kind of get your hands around. I've said it a few times now. We're going to be coming forward with Council Policy 88, 66A, Chapter 6, and we're going to be recommending some changes at the next, so please allow a little time during the ALAC meeting to be able to review those changes. It's going to be a very tight turnaround. We'll do first reading at the council July 14th, second reading and adoption July 28th. We'd like to kind of just do this in one fell swoop rather than bringing it back in piecemeal. Ordinance changes can get expensive with the company that codifies, as well as the fact that, it can get confusing when we're adding and subtracting little pieces at a time. So these are our contact numbers for you should you ever have any questions. And if you don't like or can't get a hold of, you can go to the DOR. That is their phone number and email. They do prefer that you go through the DOR alcohol and not our individual Derek's and Ann's. Because they are now kind of separated out, and these are divvied out per Ann. Ann is a supervisor, and she is extremely smart, but she's also just very limited. So I appreciate you guys staying through all of this. I know that was a lot to throw at you, and took a ton of our morning. If you have questions from here, please don't hesitate to reach out. If you ever have questions, I will hunt that down. I know how to find Wald. He will help me hunt it down. Deputy Chief Ratzlaff, we exist to assist you in making good decisions. So, thank you.
Thank you.
Thank you, Lori. Appreciate that.